Your Honor, I did something that I had no right to do, morally or legally. It was wrong, and I am sorry. I give you my word that it will not happen again. Please help me. Help us all.
On November 14, 1997, Mary Kay Letourneau sat in King County Superior Court, awaiting a decision that would determine the course of her life. After months spent in the King County Jail, this was the day her fate would be decided, prison or the possibility of treatment. As the sentencing hearing unfolded, Dr. Moore, a psychiatrist who had carefully evaluated Mary Kay, took the stand for the defense. In her closing remarks, Dr. Moore made a remarkable recommendation that Mary Kay be placed in Washington's SOSA program, prioritizing treatment over incarceration. With Dr. Moore's testimony complete, the court was left with her parting words and a sense of what was at stake. But before any decision could be made, the prosecution called their own expert to the stand. Dr. Wheeler, a forensic psychologist, was invited to offer a counterpoint to Dr. Moore's assessment. Where Dr. Moore saw a path toward rehabilitation, Dr. Wheeler's evaluation led him to a distinctly different conclusion. As part of his testimony, Dr. Wheeler carefully outlined the strict requirements a defendant must meet to qualify for Washington's SOSA program, a framework designed to help the court decide whether an individual should receive treatment in the community or serve time behind bars. Before he addressed his findings about Mary Kay, Dr. Wheeler explained for the court the specific standards and considerations used to determine eligibility.
In my evaluation of SOSA or SOTA candidates, obviously the first thing I attend to is whether or not that person is safe to be at large. If the person isn't safe to be at large, nothing else really matters. Second, in order to participate in SOSA, one has to be involved in intensive psychotherapy. And the individual, in order to participate in that, has to be employed and or have the financial resources to pay for their own treatment. I asked myself the question, did the person who is wanting to be considered for the SOSA, did that person substantially admit responsibility for the criminal acts that they engaged in? In other words, did they admit that they did the crime that they were charged with and either convicted of or pled guilty to? Obviously, admitting that you did the act is essential, and usually if the person doesn't admit that they did the act, rarely do you go further. But that's really not sufficient. The person also has to admit not only that they do the act, but what they did was wrong. Essentially, it's a fairly straightforward concept. In order to treat someone who is engaged in some form of criminal conduct, a sort of a fundamental precept is that that person needs to take responsibility for what he or she has done wrong. And in order to take responsibility for what he or she has done wrong, it's important to admit that what you did was wrong. It's pretty much that simple. Obviously, if the person does not believe that what he or she did was wrong, again, their motivation and the quality of their participation in treatment is likely to be poor. And moreover, it kind of takes you back to the safety to be at large issue. If somebody says that they did a sex crime, if they admit having committed a criminal sexual act, but says there's nothing wrong in doing that, one has to be somewhat concerned whether that individual is actually safe to be at large. And then next, I investigate whether the person has the intellectual and cognitive capabilities to benefit from psychotherapy. If the person doesn't believe that their behavior reflected some sort of problem with themselves, not with society, not with the laws, not with the behavior of the victim, but with reflected some expression of a psychological problem or disorder of their own, then they're very unlikely to have the minimum motivation to participate adequately in treatment. The next criterion states that the person must have reasonable motivation to make the changes necessary. It is possible, and it certainly occurs, that a person can admit that they have done the act, that the act was wrong, have the cognitive capabilities to participate in treatment, recognize that it reflected some sort of problem, but simply be indifferent to changing the problem. By law, sex offender treatment providers are required to engage their clients in therapy which reduces the risk to the community. And if their client cannot or will not refrain from contact with the victim of the crime, they simply are not eligible. It's not appropriate. It's not ethical for them to be allowed to participate in treatment. Actually, the treatment provider is required to ensure that the client has signed a formal contract with the provider. That formal contract imposes a myriad of restrictions on that person's lifestyle. Restrictions ranging from refraining from drinking alcohol, refraining from frequenting certain types of places, for example, places where children might be expected to congregate, to a myriad of other kinds of lifestyle restrictions. The restrictions are often difficult to meet. These are people who very frequently are not used to having constraints imposed on their independence and, if you will, on their free will. If a person cannot or will not comply with those probation and treatment requirements, then by definition and by law, they should not be treated on an outpatient basis.
And would these be indeed the minimum requirements you would look to for establishing SOSA eligibility?
Yes, very much so. These are essentially just a baseline. If a person cannot be found to meet these minimum requirements, then they're not an appropriate candidate.
After establishing the legal benchmarks for SOSA, Dr. Wheeler turned to the specifics of his own assessment. As he described for the court his in-depth evaluation process, an approach that would ultimately shape the foundation of his professional opinion. After completing his comprehensive evaluation, Dr. Wheeler delivered a clear and unequivocal opinion. In his view, Mary Kay did not meet the criteria for the SOSA program. To support this conclusion, he presented the court with a set of specific reasons, each based on his direct observations and detailed assessment. Dr. Wheeler began by outlining the primary factors he believed disqualified Mary Kay from receiving alternative sentencing.
Obviously, she sexualized and raped a sixth grade student. That's a matter of fact. But what was of concern to me regarding her amenability to treatment, by which I essentially mean whether or not she's appropriately treatable in the community, was that throughout the 7.5 hours of interviewing, Ms. Letourneau does not acknowledge that her conduct constituted rape. In fact, she only indicated the only crime, and I use crime in quotes, that she admitted that she committed was infidelity to her husband. That was in the context of having interviewed her at length, having questioned her, and having offered her numerous opportunities to reappraise her conduct. And that does not involve getting semantically stuck on the word rape. Ms. Letourneau clearly, unequivocally indicated to me that the only thing she believed she had done that would constitute a crime was to be unfaithful to her husband. She demonstrated no recognition of the abuse of trust and power that's implicit in a sexual relationship between a teacher and a sixth grade student. Throughout her evaluation, she consistently characterized her relationship with this 13-year-old boy as a relationship between equals. So when I apply the criteria from the previous chart to beating and raping a sixth grade student, I have to conclude that Ms. Letourneau does not acknowledge the wrongfulness of her behavior in any way, shape, or form. Ms. Letourneau acknowledged that she, as this indicates, knowingly and willingly became pregnant by this boy. According to her report to Mr. Compte, the first evaluator, she indicated that she became pregnant intentionally by him. To me, she indicated that it was essentially knowing and willing, but not necessarily intentional. My concern about that is that by any standard, that is a particularly egregious breach of trust and a probable cause of harm to many people, a reflection of extraordinary impairment in social judgment. And at the time I evaluated her, Ms. Letourneau had no recognition of the depth or severity of the impairment reflected by that kind of behavior. So essentially, this item is an operational and applied measure of the severity of her impairment. Ms. Letourneau indicated, again, unequivocally, her willingness to reunite with this boy. There's at least anecdotal evidence that this boy continues to be quite enthralled with her. They share a child together. One of the considerations that one has to make in determining whether a person is an appropriate candidate for SOSA is whether that person can and will refrain from contact with the victim. She's indicating that she's willing and wants to reunite with this boy. Anecdotal evidence indicates that he is certainly may be vulnerable to that. And they share a child together, which provides a potential link or access between the two. So my concern about her willingness to reunite is that it poses a very real risk of further harm to this boy.
Dr. Wheeler continued his testimony, highlighting further concerns uncovered during his evaluation. Each point, he explained, served to reinforce his position that Mary Kay was not a suitable candidate for the SOSA program. As he continued, he methodically detailed the next set of factors that informed his determination.
She indicated to me, again, clearly, that this boy forcibly raped her. She also acknowledged, somewhat inconsistently, but not entirely inconsistently, she also acknowledged that she submitted to the forcible rape. At other times, she indicated that he made very forcible sexual advances, but that she submitted to them. So she said slightly different things at different times, but throughout the evaluation, on a number of occasions, she made specific reference to the fact that he imposed his sexual will on her. And she went so far as to say, when I inquired about the issue of whether she felt she had a psychological problem that was expressed through this illegal behavior, what she said to me was that she took on the boy's problem. She took on his sexual problem. So there was no ownership that she has a psychological problem that was expressed through this sexually assaultive behavior. Ms. Letourneau indicated to me that she believed that it would be both appropriate and readily doable to fully integrate this newborn child into her family, in which there are 4 other children aged 12, 10, 5, and 3.
Does that cause you concern?
To say the least, that's a severe lack of insight. That suggests a level of cognitive impairment that raises questions, serious questions, about whether at this time this woman has the fundamental cognitive capacities to profit from outpatient therapy. I saw little, if any, evidence that she was able to address any of the issues that I've enumerated. Instead of focusing her energies on addressing these issues, she appears to have spent much of her time actively seeking publicity for herself. In my estimation, somewhat different from Dr. Moore's, I see this as an expression of a personality disorder, this attention-seeking behavior. But it certainly indicates that she's not at this time amenable to addressing the psychological issues that she would have to address immediately if she were going to be released into the community. Ms. Letourneau, as an example, went so far as to say to me that she wished that the court would communicate to the public that she had been incarcerated. but would in fact release her into the community. In my estimation, that she wished the community to believe that she was martyred by being incarcerated, but in fact wants to be released into the community. Ironically and illogically, she hoped that if she were released into the community, she could then become a public spokesperson for family values. Not only does that represent extraordinary poor judgment, but the illogic of, on the one hand, wanting the public to be deceived into believing that she were incarcerated, and on the other hand, to become a public spokesperson for family values suggests a level of cognitive impairment that raises serious questions about whether at the present time this woman can be treated in the community. As I understand it, that there were 3 separate treatment providers involved with Ms. Letourneau to a different extent and at different times. There was Marcia Macy, there was Dr. McGuire, and there was Ms. Susan Moores. Ms. Macy imposed, as a part of her treatment contract, I alluded earlier to the fact that SOSA treatment providers are required by law to have a treatment contract. She imposed on Ms. Letourneau some of these lifestyle restrictions, which are a standard requirement in sexual deviancy treatment. Ms. Letourneau, according to Ms. Macy, violated those requirements by having unauthorized contact with children, by drinking alcohol, and by being repeatedly late for appointments. In addition, Mr. Compte, who completed the first evaluation of her, and Dr. McGuire, according to a report from Dr. Copeland, indicated that she was routinely late to their appointments as well. With Ms. Moores, she apparently attended one appointment, was dissatisfied with Ms. Moores, dissatisfied with her office, and terminated the appointment and left early. This is crunch time. When you're awaiting sentencing on serious criminal charges and facing an extended period of incarceration, this is the time, in my experience with hundreds of offenders, that they are generally, not universally, but generally most able to conform their behavior to reasonable expectations. It appears to me that there's a clear pattern here. And when you also examine this pattern of violation of expectations and requirements with the publicity seeking, as well as with some of the psychological test data that we haven't talked about, I think there's very real reason to be concerned that this woman simply is not going to comply. Ms. Letourneau has an exceptionally deeply ingrained personality disorder. Nonetheless, the issue here, as I see it, isn't a question of whether she does or doesn't have a bipolar disorder, and it's not whether she does or doesn't have a personality disorder. She may have a bipolar disorder. In my opinion, she also has a personality disorder. Mm-hmm. But the question here is one of whether she can be treated and where she can be best treated. In my estimation, the depth and severity of her mental disorders makes it clear that she's not, at this time, appropriately treated in the community.
As his testimony progressed, Dr. Wheeler turned to his remaining concerns. He emphasized these final factors as crucial components of his overall assessment, underscoring why, in his expert judgment, Mary Kay should not be considered for the SOSA program.
Dr. Moore, as I read her report, indicated that she felt that Ms. Letourneau had a delusional attachment to this boy. I would call it near delusional, but possibly rising to the level of a delusion, although it didn't, in my estimation, rise quite to that level. But she exhibits an extremely intense attachment to him. I didn't see any evidence throughout 7.5 hours of interviewing and giving her plenty of opportunities to recognize that she was going to have to loosen that attachment. Even if she couldn't loosen it as we sat there, even if she couldn't acknowledge that she was ready to do it, there had to be some acknowledgement that this was going to have to change. But there was no such acknowledgement. On the contrary, she indicated to me in the most explicit possible language that she was fully willing to reunite with this boy, irrespective of other considerations. Given the intensity of that attachment, I have very real risks or very real concerns that she'll attempt to resume the relationship.
With the prosecution and defense experts having presented their sharply contrasting perspectives, the focus in the courtroom shifted to cross-examination. Now, both Dr. Moore and Dr. Wheeler would have their opinions and professional methods examined under the opposing counsel's scrutiny, as each side sought to influence the judge's final decision. During cross-examination, the prosecution began by probing Dr. Moore's diagnosis of bipolar disorder and questioned whether any previous doctors had reached similar conclusions regarding Mary Kay's mental health.
And after talking with Ms. Letourneau for approximately 90 minutes,
Right.
you diagnosed her with a severe bipolar disorder.
Correct.
So severe that ultimately it necessitated medication.
Correct.
And she was not medicated at the time that you first met with her.
Correct.
Yet you say it was very obvious to you.
Correct.
You had never met Ms. Letourneau before.
No.
You initially, when you spoke with her, had little or no information about the case.
That is correct.
You had never spoken with Mr. Gerke.
Correct.
You had never reviewed any of the police reports in this case.
That's correct.
You had not reviewed any of the histories that Ms. Letourneau had given to other evaluators or even talked to the other evaluators.
That's correct. Not at that time. On Wednesday, I did.
But this is at the same time you did make your diagnosis.
Correct.
Without doing this. And you had reviewed none of the psychological test data.
Correct.
You made your diagnosis. You say you're aware that Ms. Letourneau had been seeing Dr. McGuire. Is that accurate?
Yes. Working with him.
And you've indicated that he has very impressive credentials.
Correct.
And she had seen him a number of times prior to her incarceration.
I don't know how many times, but it was, few to several.
Yet, are you also aware that he was unable to make a diagnosis of bipolar disorder and rather suggested that should be ruled out before sentencing?
He made a pretty solid tentative diagnosis. And that, it's just a question of wording. When you see a patient, you generally make up your mind and then you try to test it. We never say, I am 101% sure or I'm 100% sure. We always allow some room for testing of the diagnosis, which is what he recommended.
But isn't it accurate to say that he did not diagnose bipolar disorder?
I think he did.
If I could draw your attention to the last line of Dr. McGuire's letter. Doesn't that indicate that he suggests that decisions on Ms. Letourneau's legal standing be delayed until it's clearly determined whether or not she has mental illness?
Right. He is writing a politically sensitive, temporizing letter. That's how I read it. Now, the most important paragraphs are, her early life is consistent with bipolar excursions. The prime considerations are bipolar versus personality disorder. Then he talks about how unrecognized it is and how important it is to diagnose it correctly. So reading this medical legally, if this patient were coming to me next, I would not read the last sentence. I would say, medical legally, this patient's a time bomb. I dare not give antidepressants. I must rule out bipolar disorder. I've got to do some heavy-duty interviewing and medications trials here. This is, you have to understand the meaning of this to a clinician versus writing this in a political atmosphere.
But Dr. Moore, isn't it accurate that Dr. McGuire did not diagnose that Ms. Letourneau had bipolar disorder?
I think we're playing word games.
Answered several
I'll
times.
move on.
The prosecution then confronted Dr. Moore about a documented hesitation that had surfaced early in Mary Kay's treatment, her initial refusal to sign a medical release form. They also challenged Dr. Moore's testimony about any improvement in Mary Kay's condition while on medication in prison, questioning whether there had been any real progress and whether Dr. Moore had sufficient evidence or time to draw such a conclusion.
You indicate that you learned on November 3rd that Ms. Letourneau was medicated beginning late in the day on November 1st.
Correct.
And are you aware that that medication trial period was not started earlier in part because Ms. Letourneau would not sign a medical release?
Well, I don't know the details of that at all.
Dr. Moore, on November 5th, you spoke with Ms. Letourneau for about 45 minutes.
Correct.
And That was Ms. Letourneau having been on medication for approximately 4 days.
Right.
And based upon that 45-minute conversation, you concluded that there had been a distinct change in Ms. Letourneau's thought process.
Correct. You can see that with Depakote. It's very fast acting. Many times you could see it in 2 days.
In fact, your report says that she had an increased ability to think about and to develop more awareness of the morals of the inappropriate relationship with the student.
Yes, I began to see some small changes in that.
But there's nothing in your report that gives examples of how her thought process regarding the student had changed.
No, but there were indications that her euphoria and her expansiveness were much reined in. She was more realistic in talking about this. And there wasn't this quick tangential response to the excesses, alluding to the excesses of the relationship. I would call excesses. She wouldn't use that word, but she didn't launch into those as readily as she would launch into those before.
But your statement says that she actually was developing more awareness about the morals of the inappropriateness of the relationship. But you show no examples of that, do you?
Well, I'm telling you about it now. I don't. A report is not my verbatim notes.
And you made these observations about her change in her thinking and thought process before you actually consulted with anyone who had been around her both before and after the medication period. Is that accurate?
That's correct.
Finally, the prosecution shifted to questions of credibility. Dr. Moore was asked about the possibility of malingering, whether Mary Kay might have been exaggerating or fabricating symptoms, and pressed to consider if Mary Kay could have self-diagnosed her own mental illness.
You indicated as early as your first report that you made to the court that Ms. Letourneau was reading a manual setting forth a criteria for various personality disorders based in part on the DSM-4.
Right. I looked up the name in my notes, and it was How the Mind Works by Dr. Hales, a psychologist. It was a kind of workbook, self-help type book.
So when you learned that in your very first sessions.
No, I learned it in the third session.
In the third session, that she was actually reading a diagnostic manual.
No, it was a self-help manual that listed some of the diagnostic criteria for. She showed me the pages on personality disorder. I don't know if they covered everything in here or not.
It set forth the criteria necessary for a diagnosis of a personality disorder.
Correct.
Is that accurate? And in fact, Ms. Letourneau took issue with some of the diagnoses that had been made by evaluators.
Correct.
And in fact, she offered her own diagnosis of herself based on criteria she read in that manual.
Correct.
You don't know whether that manual set forth the criteria for bipolar disorder, do you?
That's correct.
Dr. Moore, are you familiar with the term malingering?
Of course.
There's a layperson faking it.
Right.
And that is a concept that one would learn very early in one's psychiatric career. Is that correct?
Correct.
And the reason that that is a concern is because so much psychiatry is based on self-reports.
That some of psychiatry is based on self-reports.
And much of what you did here with Ms. Letourneau was based on self-report. Is that accurate?
In part. My observations of her in the here and now were also the other part of the diagnosis.
And the balance of it being the self-report.
Correct. Her self-reports and what was reported to be observed by other examiners in her and what she reported to other examiners.
But you did no independent investigation yourself.
Well, I talked with, a childhood friend reported independently in a letter to the judge on her sleeping style in the earlier years, earlier years in adulthood that she knew her.
But Dr. Moore, you had already made your diagnosis.
Correct.
And there's really no conclusive way to determine whether someone is distorting the truth. Is that accurate? In their self-report?
Well, you look for the here and now evidence of the disorder. You have to look for concordance with what the person is saying and what they're manifesting.
Dr. Moore, isn't it true, though, that you really can't rule out the possibility that Ms. Letourneau read a manual regarding the criteria of bipolar disorder and then responded to your questions in such a way
Yes, I can rule
you to diagnose bipolar?
No, I can rule that out, and I'd like to explain it. With all due respect, if the other examiners saw these criteria, and could not diagnose Mary as bipolar, okay? It tells you how difficult it is to go from here, from Mary. Everybody here is looking at Mary. The examiners have to look back to DSM at various criteria. With all due respect, if they had trouble identifying these highly abstract symptoms in her, how could Mary, rather unsophisticated, and even with the textbook, go from the criteria to the diagnosis and act it out? Stereotypical bipolar disorder is easy to dramatize. I'll take off half my clothes, I'll run around the room and say, I'm God, vote for me, okay? That is about less than 1% of bipolar patients. You hardly even see manic depressive bipolar patients dramatized in movies. My point is, these are very difficult, abstract criteria to act out, especially in mixed form. And please, if very solid examiners have trouble going this way, how can Mary go this way? In very, very subtle ways, reading a manual and acting it out. I don't think she can. Stereotypically, we all could. But this subtle kind of disorder with mood congruent delusion, very few practitioners know what mood congruent delusions are. I don't see how Mary would.
Once Dr. Moore's testimony had concluded under cross-examination, it was Dr. Wheeler's turn to face scrutiny on the stand. The defense seized the opportunity to question the foundation of his conclusions, aiming to expose any limitations in his assessment. During cross-examination, Dr. Wheeler was first pressed on the specific criteria he had emphasized in his evaluation. The defense posed pointed questions to uncover whether any personal biases may have influenced his recommendations. The questioning then shifted to the effects that incarceration could have on Mary Kay's family. Dr. Wheeler was asked to consider the psychological and emotional impact that separating Mary Kay from her children might cause.
Would you agree with me that the loss of a child is a very, very traumatic thing for any parent to go through?
No, I, as a routine part of my practice, evaluate parents for the Department of Social and Health Services, and I see many, many situations where loss of a child or abandonment of a child or neglect and abuse of a child is not traumatic. But as a general proposition, I would agree with you that most parents would find separation or loss of a child traumatic.
Did you find Mary disturbed by the fact that she's been separated from her children, keeping in mind that you evaluated her some 5 weeks after incarceration?
You know, I would not say that I found her particularly troubled by the separation from her children, but I would also say, in fairness, that wasn't the focus of my evaluation.
Next, Dr. Wheeler was questioned about his professional experience with bipolar disorder. He was asked whether he had treated individuals with the condition before, and what his perspective was regarding the preliminary diagnosis made in Mary Kay's case. Attention then turned to Mary Kay's physical health. Dr. Wheeler was asked about his evaluation of her while she was pregnant, and whether her condition at the time could have influenced his assessment. The defense continued by bringing up Steve Letourneau's role in the case. Dr. Wheeler was questioned about allegations of domestic violence, as well as the potential impact that Steve's alleged affairs may have had on Mary Kay's mental and emotional state.
You relied somewhat on Steve Letourneau's reporting to you his history of Ms. Letourneau.
Yes.
You were aware that Ms. Letourneau was not comfortable having you talk to him.
Yes, you and I discussed it, and you wrote me a letter and indicated that you understood that was something that needed to be done.
Right. And I also wrote you a letter indicating that on the release you asked her to sign, she had crossed that out because she did not trust his credibility and motivation.
That's correct.
Okay. And we also signed releases for you to get hospital records and police records.
Yes, and I obtained those, and I reviewed those.
Okay. Did you mention that in your report?
They were not sent to me till after my report was produced, but I reviewed the records from Swedish Hospital and from the Normandy Park Police Department. If you'd like, I can go into those.
Well, just briefly, the Normandy Park one was when she was run over or hit by the car driven by Mr. Letourneau.
I think that's a slight misstatement. The police reports reflected that she was leaning against the side of the car when he backed the car up.
And you were also aware of the history of domestic violence and abuse in the family.
There's an allegation of that, yes, in the social workers' records from Swedish Hospital. After Ms. Letourneau was examined by the physicians, the social worker met with her, and it would certainly appear that there was, if you accepted the credibility of her self-report, that there was some domestic violence.
That was a report that was consistent through the various treatment providers, indications of infidelity, verbal abuse, physical abuse.
Well, the data for all of those was the same. The data, to the best of my knowledge, I was the only evaluator that had any independent data apart from Ms. Letourneau's self-report. And of course, the data that I had was the medical records, which were certainly equivocal on the issue. You could explain the injuries from, I mean, it depends on what you think the intent and motivation was when the car backed up and she fell down. And then you have her self-report to the social worker. So the sources of data were all Ms. Letourneau's self-report, and she did indicate that her husband was, to me, she said, primarily verbally abusive at times.
And there was the report of him breaking her tailbone.
Your Honor, I'm going to object. I don't know where this is going. That hasn't factored into anyone's evaluation.
There was her, that was her self-report. Yes, that's not verified to the best of my knowledge. I know that when she was interviewed by the Normandy Park Police Department, she indicated not unequivocally, but she indicated that she preferred that her husband, that no action be taken against him.
You're aware that had her husband been arrested, her children would have had to leave the home, pursuant to court order.
Again, I'll object.
Pursuant to the court order that she not have unsupervised contact with the children? Correct. That's a logical inference, yes.
And did you talk to Mr. Letourneau about that, sort of to assess his motivations and credibilities when you were getting history from him?
I assessed his credibility, yes. I didn't assess, my job wasn't to assess him as a potentially domestic violent individual, but I paid careful attention to his credibility. I actually found him a very balanced reporter, and he had many sympathies with Ms. Letourneau.
Did you ask him if he battered her?
No, I did not.
And he indicated many of his sympathies were for her.
Yes. He said positive things about her. He said that during the early stages of their marriage, she had been a good and attentive mother, for example. And that.
Did you ask him if he was home a lot over the later years in order to form an opinion as to her habits, sleep habits, work habits?
Well, I asked him about her sleep habits. He volunteered information about her work habits, and I had, either through him or through other sources, I had a general idea of his work schedule. I know that he often worked at night and that their schedules didn't overlap, and I know that
also where he was at home a lot for other reasons.
No, I have no specific information about what reasons he might not have been home other than his employment.
Isn't it mentioned several times in the literature you reviewed that he was busy having affairs and would not be home for a while?
There was, Ms. Letourneau indicated to me that she believed he was having an affair. I don't recall that it was mentioned repeatedly. There was certainly some reference made to it in Mr. Compte's report in particular, I believe.
And that wouldn't cause you to question the accuracy of the reports you received from Mr. Letourneau?
Well, I wouldn't unduly weight his self-report either. There were difficulties simply in his, as there would be with any reporter. People have limitations to their memory. Memory is shaped over time. and you, as an evaluator, you take that into consideration.
Finally, Dr. Wheeler faced questions about the scoring of his assessment of Mary Kay and the methods used to gauge her alleged defiance. Prosecutors questioned the issue of whether psychiatric medication could impact the results of such psychological scales.
Dr. Wheeler, you said that the psychological testing showed that Ms. Letourneau scored high on the anti-authority scale. What did you find, and what does that mean?
Well, she scored high on scale 4 on a personality test, which is the most widely used personality test in the world. Scale 4 is called psychopathic deviant. What it really measures is a combination of attitudes and behaviors that typically correspond, certainly at the scale, at the elevation at which she scored, it corresponds with difficulty conforming your behavior to rules and expectations, to the law. People with scores in that range are very commonly criminal offenders. Dr. Copeland, in his letter, I think quite appropriately acknowledged that scale score was of concern, and that was a significant concern to me as well. It suggests that this is a person who, apart from her possible mood disorder, has attitudes and basically an attitude of defiance of authority. And that particular scale is not a scale that is particularly susceptible to situational fluctuations. Scale 4 tends to be a very stable scale that is not particularly susceptible to transient fluctuations. And that her score reflects significant problems with defiance of authority. And interestingly, her score on the depression subscale was within normal limits.
And that defiance of authority would or could include defiance of treatment providers?
Yes.
And could also include defiance of the courts?
Yes.
Thank you. Nothing else.
Mr. Pan.
It's your testimony. Let me ask you. And a regimen of medication and strict monitoring for bipolar disorder would not change that scale?
Scale 4?
Correct.
I wouldn't expect it to change that scale. No, it might change either scale 2 depression or scale 9 hypomania, but one would not normally expect that scale 4 would necessarily change as a response to that. No, not at all.
Thank you.
With both expert witnesses having faced cross-examination, the courtroom shifted its attention to the final testimony. Social worker Myrna Dunlop was called to provide her insights and recommendations. She began by reflecting on her time spent with Mary Kay, sharing her observations from their interactions. Myrna Dunlop then shared her impressions of Mary Kay's bond with her youngest child, baby Audrey. She offered the court a glimpse into Mary Kay's approach to parenting and the challenges she faced during this difficult time.
In terms of the contact you've had with her, what have you observed of her emotional state during this process?
She has been extremely tearful, highly distraught is how I have observed her. In regards to multiple losses, the loss to her contact with her 4 children, and the situation in which she has found herself.
Has she shown signs of remorse?
Yes, she has certainly talked about how difficult and how painful this particular situation is, if that's defined, and how it has affected her, and her family on many, many levels. This has huge ripple effects.
Have you observed the child, Audrey?
Yes, I have.
And how does she appear?
Audrey is an extremely sturdy infant who engages the environment. She is a particularly healthy infant who will engages me when I pick her up, engages Mary. I took her to the jail. I took her to the jail for at the time of the shelter hearing. As soon as she saw her mother, her legs were wiggling.
Your Honor, I'm going to object to this. This was not my understanding of the testimony of Ms. Dunlop.
As Myrna Dunlop's testimony continued, She was then asked about Mary Kay's ongoing contact with her other children by phone. She explained for the court how these communications had been managed, outlining the measures put in place to monitor and support their interactions during this period. With her account complete, the prosecution turned to cross-examination, challenging the reliability of Dunlop's assessments and probing deeper into the complexities of Mary Kay's actions. They referenced a letter Mary Kay had sent her son, encouraging secrecy as evidence of questionable judgment.
You said you were aware that under the criminal order that Ms. Letourneau could have contact with her children as long as it was supervised. Are you also aware that as recently as a letter of October 6, 1997, in a letter to her oldest son, she writes, "I insist that you address the letters yourself. When Daddy sends the letters, it makes me feel like he is reading our letters to each other. That is illegal, as it is also not legal for him to be on our phone calls. It makes me feel threatened in an unnecessary way. So please address and seal and send your letters privately. Send them from the grocery store mailbox or any big post office mailbox. It is your right to send me private, honest mail." Are you aware of that, Ms. Dunlop?
I'm not aware of that letter.
Okay. But that would be a violation of the court order. If what she is asking her son to do was done.
Conclusion.
May I answer the question?
She is encouraging essentially her son to do what is against a court order. Is that accurate?
I gather from that letter.
Okay.
With all expert testimony complete, the court prepared to hear final arguments from both sides. The attorneys would make their strongest cases, one for punishment, the other for rehabilitation, before the judge listened to those most personally affected by the proceedings. As closing arguments began, Mary Kay's defense attorney addressed the court first. He emphasized that this was not a question of consent or special exceptions, but rather a case requiring careful consideration of context, arguing for community-based treatment rather than prison. The defense pointed to the complicated circumstances that shaped Mary Kay's actions.
This is not a case about consent. On statutory rape or rape of a child, consent is not an issue. And the number of letters the court has received, the calls I have received about, there was no gun, there was no weapon, that's a different crime. We're not talking about consent here. The young boy could not consent any more than he could consent to go buy a car down at the car lot. He could not consent any more than he could consent to being abducted for an interview. Consent is not what is at issue here. Dr. Wheeler says that she saw this as a relationship of equals. That's the bipolar signs that Dr. Moore pointed out. The pregnancy was intentional. That's the bipolar, the looking for the replacement for dad. No recognition of the severity of the impairment. Again, bipolar. The willing to reunite with the victim. That's the bipolar. That's the out-of-control person that Dr. Moore says on the medication is coming down, is starting to realize what's going on and the wrongfulness of it. Acknowledgement that she took on the boy's problem, an aggressive male or what have you. That's part of the grandiosity. She can solve everything. And that's her mindset that is being worked on as we speak now. There are many victims in this case, Your Honor, and in justice, everybody has to be considered. We're looking at punishment, deterrence, and rehabilitation. And I won't ask people to stand up because of the security concerns here. But there are many, many people here, Your Honor, that are going to help Mary follow those conditions, that are not going to allow her to have contact, that are not going to allow her to be late, that are not going to allow her to do the things people fear and are talking about. I'm asking you to give her a chance. If you send her to prison, she doesn't have that chance. If she goes into a treatment program, the CCO is going to be on her. Dr. Copeland's going to be on her. God knows the state, the local authorities, they're not going to cut her any slack. Tell her now she's got one chance. She's been locked up a long time, protective custody. She's been punished. And when they talk about deterrence, when they talk about sending a message to other teachers, can you envision one teacher that would say, Mary got treatment, I'm going to go through that? She's lost her family. She's lost her career. She's lost her self-respect, her esteem. All the lurid details have been out. The fact that she was caught is deterrence, Your Honor. You're not going to find a single teacher that's going to say, well, I'm going to do this. Mary got off light. I'm asking you to give her a chance. I think she's made progress over the last couple of weeks, and I think the weight of the opinions of people that say she is treatable and that are willing to commit to the court to monitor her and report any transgressions outweighs the respected opinion of Dr. Wheeler, which is also well considered, I must add. But the 3-1, if you will, I think he's in the minority on this, and everybody has had the same training qualifications as he has.
With the defense's final appeal delivered, the prosecution rose to present their closing argument. They shifted the focus back to the seriousness of Mary Kay's actions and the importance of accountability, urging the court to consider the lasting consequences of her choices.
Your Honor, as a society, we have little tolerance for adults who use our children. Adults who manipulate and exploit children for their own needs. Adults who shatter the boundaries between childhood and adulthood and rob children of their innocence and rob children of their youth. Mary Letourneau is no different than that. She is an adult who abused a boy, a 6th grade child. She committed a crime, a serious crime, as an adult, as a teacher, and as a member of our community. And she has pled guilty to 2 counts of rape of a child in the 2nd degree. In determining the appropriate punishment, we start with the presumption that adults who sexualize their children go to prison. The legislature has set forth the standard ranges. The people of the state of Washington have set forth a standard range for the offense that Ms. Letourneau has committed. The standard range for this crime, the legislature has set, is 67 to 89 months. Only recently, the legislature increased those penalties because of how serious we believe this crime to be. Now, it is true that in the state of Washington, that the legislature has carved out an exception, a very limited exception. It's called the Special Offender Sentencing Alternative that we've talked about today, the SOSA. But it is an extraordinary privilege because it forgives the standard range, a lengthy standard range of 67 to 89 months, and allows a sex offender to be treated in the community. And in determining who should be eligible for that program, the court needs to ask itself 2 questions. First of all, is the offender amenable to treatment? And the second question, a very important question, is whether the offender is deserving. In Ms. Letourneau's case, the answer to both those questions is no. She is not amenable to treatment, and she is not deserving of community-based treatment. We urge the court not to be sidetracked on the issue of bipolar disorder. Even Dr. Copeland, in his recent letter of November 5th, indicated that the bipolar issue was partly a red herring. And we suggest that it is a smokescreen designed to confuse and obscure the real issue that is before the court. Is Mary Letourneau deserving? She is not. Her abuse of trust was extraordinary. She abused the trust placed in her as a school teacher, as a mother, a wife, and as an adult. She exploited a child who was her student, who she knew from second grade, who she had identified as even being at risk, a vulnerable student, who had trusted her in the second grade and now found himself in her sixth grade class. She exploited him for her own needs, her own selfishness, and her inadequacies. She told him not to tell. She wrote letters to him to keep him within her grasp. And she knew it was wrong. She was put on notice when she was stopped by the police in a darkened parking lot with the boy in the back of her car. Today, she blames the victim. She holds fast to her denial that the only moral wrong she committed was having sex outside of marriage. And she fails to acknowledge the harm to so many individuals, which have had far-reaching impacts on a number of children and adults. And in the letter provided to the court, the recent letter to the court, she still is in defiance. And it is clear that she was, as recently as 1 month ago, actively soliciting her own child to violate a court order. Ms. Letourneau is a marginal candidate at best. The evaluators who are even willing to take her, frankly, have very little good to say about her. The court should not be putting itself in the position of granting this extraordinary privilege of a SOSA sentence to a poor or marginal candidate. And as shown through Dr. Wheeler's testimony, she can't even reach the minimum of requirements to be amenable to treatment. Ms. Letourneau is an adult who is a child, a sixth grade boy. We cannot tolerate her behavior. She has done nothing to demonstrate that she is deserving of community-based treatment. Her behavior merits punishment, and we urge the court to impose a standard range sentence of 78 months.
After both sides concluded their closing arguments, the courtroom's attention shifted to those most directly impacted by Mary Kay's actions. The victim's mother, Suna Falau, approached the bench, prepared to share her family's plea with the court.
Being here today in person has not been an easy choice for me. It is not because of Mary or the sentencing. It is because I am a private person and I like my privacy. But because out of my love, faith in Mary as a fellow human being, and empathy for her, I am here. I have been asked by many, how can I forgive her? In searching the word forgive, Webster says, to forgive is to excuse someone for a fault or offense. A second definition says to forgive is to stop feeling anger or resentment against this someone. In the beginning, I have often asked myself this question: how can I forgive Mary? As it was then in the beginning, as it is now, the answer has always been the same. I can forgive Mary because God, through Jesus Christ, has forgiven me. So who am I not to forgive Mary? Mary is not a bad person. She's just a human being that made a terrible mistake. I'm not here only to plead on my behalf, but on behalf of the 6 minor children that will be affected by what happens today here in court. I've heard what the prosecutors have recommended, and I feel that Mary has been punished enough for her mistake. I do not feel that is a crime. My son does not feel victimized. I plead on behalf of my granddaughter that to send Mary to jail will not benefit anyone. Receiving treatment will help her with whatever problems she has. And once again, I ask you, look deep into your heart. Society wants Mary cast and put away into jail. Society does not wake up at 2 o'clock in the morning when the baby cries. Society will not have to face a 14-year-old boy with the guilt that he may feel if you sentence her to jail. He will carry this guilt with him as long as she is in jail. So I plead today, please send Mary to treatment. Jail will not benefit anyone. And as God has forgiven us, let us as society forgive Mary also.
With the mother's words still echoing through the courtroom, a tense silence settled in the air. With all voices heard, it was now up to the judge to reflect on the evidence, expert testimony, and heartfelt pleas before delivering her decision, a sentence that would shape the futures of everyone involved.
This has been an extremely difficult case in many, many respects. I have carefully read and reread the reports of the mental health experts that were provided to me both by the state and the defense. After consideration of these materials, the evidence, and the statements presented today, I am satisfied that the defendant is amenable to community-based treatment, and that the community and the defendant would benefit from such a sentencing alternative. I am further satisfied that Ms. Letourneau does not pose a safety risk to the community under this sentencing option. The mental health experts uniformly agree that there is no evidence of any predatory and that the defendant's offenses were limited to this young victim in this case. I am persuaded overall by the experts' opinions and the express wishes of the victim and his family that community-based treatment is appropriate and warranted in this circumstance. Ms. Letourneau, you are being granted the opportunity for treatment in the community rather than in prison. Whether you stay out of prison is completely within your hands. It will not be easy. You will not simply be released into the community to resume your former life as you knew it before. From the moment you are released, and for the next few years, your life will not be your own. Your comings and goings, your daily life activities will be closely monitored and supervised by the treatment provider and the Department of Corrections. You will be required to strictly comply and adhere with all treatment plan requirements, supervision conditions by the Department of Corrections, and court-imposed conditions, of which there will be many. Violations in any degree will not be tolerated. If you fail to comply with any conditions, either of this court, imposed by the Department of Corrections, or any of your treatment providers, it will result in immediate revocation of the suspended sentence, and you will be committed to the Department of Corrections for 89 months.